Good morning, Ms. Norman White.
Good morning. May it please the Court, I'm Jane Larman White. I appear today on behalf of Tyson Benoit. Mr. Benoit was charged with first-degree murder as a result of an interracial altercation. The judge refused...
Ms. White, I have a question about the jury challenge, the issue you raised. Was the fact that the white juror who was seated, who taught autistic children, was the fact that a white juror who had a similar occupation to this juror who was challenged, was that fact brought to the judge's attention below?
No, not to my recollection.
So then isn't that waived? Because that's the argument that you make on appeal. Your main argument is that, and it could have even been strategic not to have brought that to the judge's attention because the defendant might have been afraid that both of them would have then been thrown off. And so he might purposely have done that. So, but at a minimum, don't you have to bring this to the attention of the judge? This race-based challenge is the only one on occupation, and you've only raised it here?
No. My contention is, and frankly, I would like to remember a little better the sequence of events, and I don't, and I apologize for that. But my contention here is that the proffered reason was not adequate as a matter of fact, and that is a separate contention from
But a main reason that you raise in your brief is that it wasn't adequate, as a matter of fact, is because you say a white woman with the same occupation wasn't challenged, and that was not brought to the judge's attention, you tell me.
No, it was not, but it is proof under the circumstances that it lacked genuineness.
But then how can the judge make the decision that this is not a proper challenge if that fact was not brought to his attention below?
Well, the judge, as my reading of the record, and I believe it's supported, is that he did not make the precise two considerations.
Well, we've inferred in other cases, we say, if the judge didn't do step-by-step,
but he
we
said that he believed it was genuine, and therefore he sort of didn't consider the adequacy of the challenge itself. I have contended that the adequacy of the excuse was lacking.
But the district attorney justified it on the basis of occupation, and then the judge says, after it goes through the presumably proper steps, says, okay.
That the second contention about the genuineness of it, that's what's called into question, the genuineness of it, by the failure to challenge the similarly situated.
But you didn't raise that to the judge below, so the judge wasn't aware of that.
The judge, and my contention here, is that the excuse and explanation was inadequate, period.
Per se. But you use that as an argument. But the judge found that it was, that an occupational reason was sufficient.
Actually, what I believe he did was say that it was genuine.
Right, so he implicitly found that the reason given was sufficient.
I don't believe that he implicitly made a finding about the adequacy of the explanation. I believe he believed and ruled that the genuineness of such a challenge was sufficient. And I've cited Maldonado, and I think Maldonado is very much on point for this contention, that even if this were barely adequate, the genuineness of it was refuted by the failure to challenge a similarly situated white potential juror.
But you didn't bring that up below. So the judge didn't have that in his mind to make that.
There was no waiver of the challenge, of the peremptory challenge of the black juror. There was no waiver.
No, I understand there wasn't a waiver of the challenge, but the reason that you're arguing here was never brought up, so the judge couldn't have used that in his decision-making.
If, in fact, that juror were long gone, and this is where I would like to be more familiar with the record.
She was in there, I believe.
But I would not anticipate that the trial attorney had the leisure that I had to go line by line over who might have had a similar occupation.
Well, nor the judge.
And I don't believe that it was incumbent upon the defense attorney to have that leisure in order to preserve his right to a racially adequate jury under the circumstances.
No, but without that, what I'm saying is that without that, there's no reason to question the judge's decision that the occupational challenge was justified. I mean, there were challenges for those reasons all the time.
I believe that there is, for the reasons I have stated in my brief, that it doesn't make sense as a matter of adequacy. It doesn't make sense. That sort of covers what I wanted to cover initially, but I know that this court granted direct appellate review on the basis of my application concerning the adjutant issues. So I'll move to that. The most focused evidence supporting self-defense in this case came, in fact, from Teresa Hopkins, sort of late in the Commonwealth's case. This testimony focused like a laser on what was the final altercation. And I would argue to this court that in Adjutant and in Pring-Wilson, this is absolutely crucial. In Adjutant, the quotation is, "who attacked first in the final moments before the stabbing." Also there that the judge kept from the jury potentially exculpatory information, quote, "about the possibility that the victim attacked Adjutant first in the final altercation."
But those were cases of self-defense, and here the judge ruled there was no self-defense.
Well, my point in talking about this is that the judge incorrectly viewed the whole sequence of events and did not focus on what was the final encounter and altercation. He, in fact, went before. And this court, for instance, in Adjutant, focused instead of all the times when Ms. Adjutant could have given the money back and left, or was on the phone with the dispatcher and could have left, and so on and so forth, instead focused on the point of the final altercation. The judge here recognized the merit of that only when he raised and said he would charge the jury on reasonable provocation, on sudden combat. In that context, the judge recognized the focus point of the actual stabbing, the actual fatal altercation, and did not go back and talk about what went before. His reasoning was that he thought it clear on the evidence that a jury could find that the defendant was not what was called the persistent aggressor. My argument to this court is that the jury should have been charged on self-defense because the similar focus on that final altercation was required in the context of ruling on whether there was a right to a self-defense instruction. I've cited in particular the case of Commonwealth versus Fortini, which recognizes that not only can there be a valid self-defense issue, but also a reasonable provocation on sudden combat.
So your whole Adjutant argument here rises or falls on whether we believe the judge was correct in his ruling that there was no self-defense.
No, not at all.
Going beyond
But
that.
I do not waive that issue at all, and it was not waived below. I'm arguing that in Adjutant and in Pring-Wilson, instead of focusing on whether Pring-Wilson shouldn't have gone back to the car, shouldn't have uttered an expletive, that in fact in the situation in which he found himself, however stupidly, being drunk on the street and confronting a larger group of people who were his size, that he found himself on the ground being pummeled. And he believed at that time that he needed to defend himself against possible deathly attack. This court took pains to say that the three, quote, Harrington factors were present at that time. And so I want this court to focus and utilize the analysis that was used in both Pring-Wilson and in Adjutant, that you focus on the final fatal altercation.
And if we do that, we've got the defendant who was much smaller than the deceased, but by about a foot.
Inches, I believe.
And they're bent over,
Yes.
and you would say that's what we focus in on.
Well, you focus in on who was the initial aggressor in that final confrontation. And as I've indicated, that the most focused evidence about that is, in fact, the testimony of the deceased's mother, who came out on the porch and who said that
He leapt off the porch.
she temporizes and says it was an explosive thing. And then when there's a temporizing, well, maybe he slipped or maybe he was pulled. But certainly in the situation in which the jury found itself, being instructed on reasonable provocation and sudden combat, her temporizing would have left it open to a jury to say, oh, well, gee, maybe, the defendant dragged him off the porch or he slipped. When in fact the adjutant sort of evidence, the prior violent incident, would have been extremely probative on whether or not it was likely that the deceased in fact jumped explosively off the porch and battered the defendant with such force that there was no getting away from him, along with the size.
Go ahead.
Could you address the judge's ruling about the incident that occurred before this, where the victim and his friends attacked another black guy?
The judge's position below was what I brought to the court as a direct appellate review issue. The judge believed that by its terms, adjutant was confined solely to cases of self-defense and who was the, quote, first aggressor in a self-defense case. And the judge, having ruled that he would not charge on self-defense because he believed that first aggressor was not presented on the facts and that the defendant should have, quote, retreated at some point earlier on, that adjutant didn't permit him to exercise his discretion one way or the other as to whether to admit the evidence.
Well, for focusing on that, didn't the judge, in a sense, give you the benefit of the doubt of adjutant in his analysis and say, okay, Hopkins was the first aggressor, but the defendant here did not act, there was no evidence that he attempted to flee in circumstances where he should have fled. And therefore, it's for that reason that I'm not giving you the self-defense instruction. It's not the adjutant issue.
Because
Oh,
when
I
when
agree. It's not-
the deceased jumped off the porch, there's no evidence that he jumped onto the defendant. I mean, at least that I read in the briefs. I haven't read the transcript. It was just the best you get is that he somehow off the porch. He may have jumped, and there's no evidence that he jumped onto the defendant.
Oh, I believe that the inference is clear that the combat started immediately. and
Okay,
that
maybe that's the combat, but no, I'm saying there's no evidence that he jumped onto him and not such so as to knock him to the ground. So I'm saying the defendant still could have escaped. This is outdoors.
Well, this goes back to what is a jury issue and what isn't. And I suggest that that is precisely a jury issue as to whether or not there were, in the circumstances, possibilities of retreat. At that point, it's my understanding from the judge's rumination is that his notion of retreat came earlier, particularly if he credited at least one version of the testimony of Brandon Johnson, that the defendant came across the street and got a knife and then returned to do combat. But even on that scenario, I would suggest that the proper focus is what happened at that initial final altercation, whether or not...
What is the evidence most favorable to you on when he got the knife? Because it seems important to me that he, at some point, got the knife from his friend so he could, I guess, fairly participate.
The defendant's statements to the police less than 24 hours after the altercation were varied, and they were recorded.
What's the most favorable evidence that
The most favorable evidence is that they were that he and Brandon Johnson, the defendant and Brandon Johnson, his friend, were standing there in the yard, that Anthony Hopkins was on the porch, that Anthony Hopkins said, "I'm going to stab you niggers," and that at that point, the defendant's statement is that he said he was going to stab us, so I figured he had a knife, so Brandon Johnson gave me his knife. And
So at that point, I take it, so that's the most favorable evidence.
Yes.
That this is a verbal dispute. He's on the porch. He's of his house. The defendant is off the porch.
Off the porch,
There's
but-
this verbal dispute, and he says basically to his friend, "Give me the knife," because he said he's going to stab us.
I frankly think that the defendant wasn't even aware that there was a knife and that Brandon Johnson gave him the knife, that it was Brandon Johnson's knife.
Okay,
But-
so he just his friend just put a knife in his hand. That's the most favorable evidence from here. So I take it at that point the judge wouldn't be able to find, well, it seems to me he had opportunity to retreat. He's not, as Justice Cowan was suggesting, someone's not on top of him at that point.
But on...
So that's the okay, go ahead.
But as I think Fortini makes clear, that arming oneself for the possibility of a potential conflict, however stupid, I cannot stand here and say that my client was a model of civility or intelligence, but as a matter of law, arming oneself for the possibility of combat is not the equivalent of malice, such that self-defense would be defeated at that point from the get-go.
But it still seems to me that there is the opportunity for retreat there. If there's the opportunity to get a knife in whatever way, at that point he's outside and could leave.
Well, as an interesting footnote, I noted that the amicus brief filed by Machtel in a footnote speaks about the possibility of retreat or not when in such close quarters and whether one can retreat safely. That in fact it was very close, that if somebody's
But the
above
people
you and
around him
offering-
were his friends.
Excuse me?
The people around him were his friends, the people who were throwing rocks at the victim.
No, there was only one individual who was accompanying my client up the street, and that was a younger male, Brandon Johnson.
And
who in fact had the
presumably
knife.
after he handed your client the knife, he actually walked away.
He, according to my client's statements, he was very much present in the yard even at that time, and that he was acting, the client's statements were that he was acting to protect not only himself, but the younger Brandon
Oh,
Johnson.
I thought he left.
That's certainly his testimony.
That's
Brandon
what he
Johnson's testimony is
testified.
certainly that. I just wanted to come back. The Justice Freeland's question was that it stands or falls on the self-defense. The adjutant issue, after the judge ruled that he would not consider whether he said he didn't have the authority to do so because there wasn't self-defense. But the trial attorney at that point made the specific argument that the same considerations apply in terms of what he was charging on, the reasonable provocation on sudden combat. And the relevance of such evidence here was certainly at least as compelling as it would be in the self-defense case, particularly when the testimony of Teresa Hopkins had him getting off the porch rather quickly and a fracas ensuing which resulted.
So
in the
you're
death.
saying the incident that happened earlier, even apart from the question of self-defense, it was relevant to the question of reasonable provocation, and he was entitled to a charge on that, and he was entitled to present the evidence for that reason.
For that reason, because in fact what was the issue was whether or not the deceased was so motivated to jump off and have an explosive confrontation of violence with the defendant, who by all accounts was not on the porch but was in the yard.
Thank you, Ms. Longman-White.
Thank you.
Mr. Cacciaviello?
Good morning, members of the panel. For the record, my name is Paul Cacciaviello. I am, for the record, I was trial counsel.
Can I ask you, did the Commonwealth object to there being a self-defense instruction?
Yes. And, Your Honor, I would point out,
Why?
because there was, the Commonwealth's view of this case was that we had a defendant who followed a victim home, who threw rocks at him, who prior to following him home indicated to his friend that he wanted to go mess with him. We had a victim who tried to get into his home, who was then pelted with rocks that didn't hit him. They were aimed for him. Commonwealth's view in the first instance, and this was our view as to why self-defense in the first place ought not apply, but there's a second reason too, which is what the judge actually ruled. That the defendant in that circumstance was the aggressor. Was the aggressor from the moment he saw the victim walk past him as the defendant was on a porch with a bunch of his friends. So that was the Commonwealth's point. And I think what happened in this case is that the judge took what I would consider to be perhaps the easier element, and that is, did he retreat? Did the defendant retreat at the point in question here? Because Commonwealth's view was that he's the first aggressor of the defendant, so he ought not get the instruction in the first place. But there's a second component, the duty to retreat. And what I think Judge Ford did in this case is he took a limited view, a defendant favorable view, as he has to do. And at the point in question here, when the defendant, when the victim came off of the porch, what's lost, or what can be lost if not a careful review of the transcript, is the defendant had to leave the area of the victim and go over to Mr. Johnson, whether that be 10 feet or across the street, because there's evidence.
Well, that's why I asked if there were anything in the transcript that indicated that the victim actually jumped onto the defendant. I didn't think so from the
There is
briefs, but I
nothing,
haven't read the
Judge.
transcript.
There is nothing, and I would suggest that we can take judicial notice that a street is probably 10 feet wide, but the evidence was about 10 feet or going across the street.
Okay,
And
but we've
two,
got to look at it from the defendant's point of view, so.
Oh, absolutely, Judge. And so with 10 feet, let's go with 10 feet. That means the defendant, by the transcript, by the evidence, had to walk over or run over to the Mr. Johnson, retrieve the knife, and more importantly, go back towards the victim.
Counsel,
That's-
now,
Yes.
that was Mr. Johnson's testimony,
That-
but the defendant's version was that he just turned to Mr. Johnson, wasn't it?
No, I think, Judge, if I may, I believe, obviously Mr. Benoit did not testify in the case.
But his statement came in.
His statement came in. His statement was that he, if I can recall this correctly, that he went back to Mr. Johnson to retrieve the knife, but then came back towards the victim. And I think and frankly, Ed, I can certainly appreciate Judge Ford's ruling in that case. That's not retreat. In fact, that's quite the opposite. And if you have no retreat, as the court's well aware, you do not get self-defense. And as though the Commonwealth's view was more expansive, in other words, if from the get-go, victim walking, passing the defendant was the aggressor from initially, I certainly can appreciate Judge Ford's ruling that there simply was there was simply no retreat here, nor was there any evidence that the defendant wanted to retreat. Certainly not because he didn't testify, but certainly not from any other source of evidence.
Now, your position is that the earlier incident in which the victim was involved with other people to threaten a black man is not relevant to this.
It is not relevant, Your Honor, for two reasons. Perhaps more, but at least two primary reasons. First of all, as to the adjutant ruling, I think this court was emphatic in its ruling that it applies only to self-defense. Without self-defense, that is simply not relevant. This also, and I know the court's aware, having read the transcript, should be pointed out that this defendant, Mr. Benoit, did not have any knowledge whatsoever of that prior incident. And if that's the case, under the sudden combat theory, as I read the case law, there is a subjective component in the sudden combat.
Wouldn't that shed some light, though, on whether there was provocation or not?
I'd suggest not, Judge, because what that does is it further erodes, what we would suggest further erodes, the rule against habit evidence. Simply because he doesn't know about it. I think it's a different position and probably comes in for other reasons if the defendant is aware of that prior confrontation. But in this circumstance, where Mr. Benoit has no knowledge whatsoever of it, then it has no bearing. It is not material because how can it impact his state of mind if it's not in his mind? That's why that evidence certainly ought not be admissible. There's a long-standing prohibition against habit evidence. And I think if we go down a path of allowing in unknown events to the defendant in this circumstance, simply because, well, he did it on one occasion, he must have done it on another occasion. That's what habit evidence says ought not happen. In limited circumstances, certainly, I'm aware of that, but not in a circumstance here.
Can you tell me how much time passed between that first incident and this one?
The best we could determine, Judge, was probably a couple hours, probably 2 hours.
2 hours?
Probably 2 hours, I would suggest.
Isn't what you say, though, doesn't that suggest that adjutant, isn't habit evidence, as you care to put it, also underlie adjutant?
Oh, it does, and I've read the adjutant evidence several times, and I know that there was a strong Commonwealth argument against that, and the point was made there, and I certainly can appreciate this court let in habit evidence, but on a limited basis. Commonwealth's position is it ought to end there, particularly in this circumstance. I know that it comes in, but that's my point is it ought to remain.
In adjutant, we look to a lot of other jurisdictions to see where the law had gone, how this type of evidence had been treated in this limited context. What about the law of other jurisdictions in this broader context?
Well, and certainly, and I think the dissent in adjutant had pointed out that there was some difference in application in terms of whether reputation evidence would come in or specific act evidence. And
No, but I mean in the context of using this kind of evidence, not in a self-defense case, but to establish that, for example, the victim likely provoked or likely engaged in sudden combat, or...
Your Honor, and I apologize, I'm just trying to understand your question, but if the question is other jurisdictions have done it, why shouldn't the...
No, my question is
Have
whether
they?
other jurisdictions have expanded this, well, we will call it the adjutant ruling, but allowing this type of evidence in very specific types of self-defense cases. Have they expanded that reasoning beyond that? Do you know?
Your Honor, I think that they have. I tried to, in preparing for this argument, to review the 50 states, and I have to tell the Court I was not entirely successful. I do think that there was some cases cited that expanded it in the Commonwealth. So I don't quarrel with that, and our position here simply is that that adjutant was very, that the court was very emphatic in where it applies.
Mr. Kakevela, could I
Yes.
ask you this question? It seemed to me that there's another set of facts here, which is the prior altercation between these two, this particular victim
Yes.
and at least this defendant and a group of friends, where, as I understand from your brief, the victim in that case had got the better of the fight, I think was your words, even though he was set on 2-1 or 3-1, maybe, whatever. In light of Justice Cordy's question, which way does that cut? In other words, that evidence comes in, and there's not a challenge to that.
Right.
So if the jury is left, so the jury knows that there was, as it were, a kind of personal animosity. In light of the episode that had occurred prior that night, one could say it wasn't so much personal, it was a kind of ongoing black-white fight. And I'm not sure which way that cuts. On the one hand, it swings the door open too much further. On the other hand, you could say, look, there was plenty of evidence for them to know that there was enormous animosity, and they had that, and that was plenty.
You're right, and had anticipated perhaps a question from the panel about that, and I think which way that cuts is that the jury was not deprived of that evidence, and certainly they could consider it, and as you say, it could cut either way. And so this is not a circumstance by excluding this event some 2 hours earlier, yet unknown to the defendant.
Did you,
Yes.
I'm saying you because you were trial counsel, did you use that evidence of the prior altercation in your closing argument?
I believe I referred to it because there was the statement.
To make what point?
Intent, right?
I'm sorry,
It was
intent. It
intent.
went to the
It was-
intent because there was a statement made by the defendant, at least the evidence was that it's going to mess with him. And there was a statement also, I believe, saying,
He was the
making
one.
reference to that prior incident. And so the Commonwealth argued that as intent. In other words, that why was the
Okay.
defendant following
Yeah.
Mr. Hopkins? And so that's how that was used. But the jury could use that evidence, obviously. I mean, I used it for intent, and as to how they viewed it, I'm not sure. But the so I agree with you. I think it could cut both ways, but it also goes to the point that the jury was not deprived of some evidence concerning the victim's ability to get into a fight or a confrontation, if you will. So if I may, Your Honor, and I do just, if I do want to address, and obviously I'll answer whatever questions the panel has, but if there are none further concerning the jury selection question, but
Well, let me ask you a
Yes,
question
sir.
about
Yes,
the
Judge.
sort of a variation of the adjutant issue.
Yes, Judge.
Why wasn't the evidence of the prior incident from a couple hours before, or even in the evidence in its light most favorable to the defendant, the shortest period of time that it could have been? Why wasn't that prior incident admissible on the question of provocation?
Well, and Judge, in the sense of, well, I go back to the point that if the defendant is not aware of that prior incident, I think it has less bearing.
Well, he was in the middle of it.
I'm sorry, maybe I'm talking
Wasn't
about,
it the evidence that there was a confrontation, an earlier confrontation between them?
that was the year prior, Judge. I thought you were
Okay.
referring to
The one that was 2 hours before.
that's the one that, no, the defendant, and that's an incident that the defendant was not involved in.
And he didn't know
Right,
about
but
And
the
he didn't
victim
know
was,
about it.
but it was the victim.
But isn't the evidence, why isn't that evidence admissible to show provocation?
On the victim's part, right? That's what you mean?
Yes.
Because if he,
I guess I'm misunderstanding the question.
The defendant's, the victim is a troublemaker. 2 hours before he had made an assault on some people.
Yes.
Why wasn't that evidence admissible here to show provocation?
Okay, in other words, the victim was provoking the defendant.
Yeah.
Right.
Because I would suggest, Judge, that again, it makes it less relevant if the defendant's unaware of it.
You're saying the defendant had to know of that?
I would say if he knows about it, I think it's fair game that it probably does come in under.
That was the import of my question, because of in fact, as I understand, this piece is not disputed by the defendant. If the reason for the altercation that resulted in the death of the victim was really the provocation that came from the earlier fight a year previously.
Right.
And as I understand it, the victim at this point was at least possibly inebriated because he was
In
staggered.
all likelihood, yes.
I mean, he wasn't. Whatever had. That episode, not known to the defendant, where there's no question that the victim was walking away. I'm not talking about the moments immediately before, but he was walking away, and he is being followed by and had rocks thrown by two people. There's no suggestion that he was out looking for a fight with two other people that night.
There's absolutely no suggestion of that, Judge. There's
So
absolutely not.
So at least as I was trying to think it through, my thought is that while in some circumstances the evidence to which Justice Spina referred might come in this set of circumstances, it doesn't come in because there's some other evidence that makes it clear what's happening here, so that it's not the...
I think that's a fair point, Judge. I mean, as you say, the facts.
I don't know if it's fair or not. I mean, it just occurred to me that... yeah.
But no, I guess my point is it sort of dovetails with my argument here, which is that the facts of this particular case, as I started this argument.
In this set of circumstances, the defendant and his friends, started off as the troublemakers.
That was our argument, that he was the aggressor from the get-go. And I just,
whether that deals with the adjutant issue right before the fight is a separate issue, but at least for how this thing got started, it wasn't because he was an aggressor earlier that evening and he was out looking for another fight or something.
Yes, Your Honor. And I'm noting my time, and obviously, if the Court has another question, to quickly address the...
I think your time is up. Thank you very much.
Okay, Judge. Thank you.